Now to tonight's Fox 7 Focus. On Monday, Governor Abbott signed SB 4. That controversial new law enables Texas police to arrest people they suspect of crossing the border illegally, and it allows judges to either send them to jail or send them back. But just one day later, the ACLU and other groups filed a lawsuit trying to prevent that law from taking effect in March. I sat down with constitutional law professor Eddy Carder from Prairie View A&M to discuss the law, the lawsuit, and what happens next. This law that Governor Abbott signed on Monday, what is SB 4?
SB 4 is essentially a law passed by the state of Texas that makes it a state crime to illegally enter the U.S. And the emphasis there is upon the concept of a state crime. It makes it a state crime.
And it took literally less than 24 hours for the ACLU to come out with this lawsuit in conjunction with the Texas Civil Rights Project. Talk to us about that lawsuit. What's kind of the gist of it?
That particular lawsuit says that essentially that this particular issue is not a matter of state concern. It is a federal matter. It is a federal concern, and that the state is overstepping its bounds and limits, and that this law, therefore, is unconstitutional because two areas have traditionally been entrusted to the federal government. Those two areas are immigration law and then issues of foreign affairs. And essentially, this challenge by the ACLU says that the particular law, SB 4, oversteps the bounds of the state on both of those counts.
Where do things go from here? Obviously, it looks like we're going to expect an appeal from Governor Abbott's people. How do you see this lawsuit proceeding? Do you think it has teeth?
This lawsuit certainly has teeth. It rubs directly up against and conflicts with the supremacy clause of the U.S. Constitution. If a state law conflicts with a federal law, then the state law is unconstitutional. It also flies in the face of various Supreme Court rulings. This specifically 2012, the U.S. versus Arizona, I believe it was, or Arizona versus the U.S., where the Supreme Court came down on the side of immigration being entrusted to the domain of the federal government. And this law has been passed, essentially, it seems, with the objective of testing the limits of that law and seeing if we could find some kind of mediating position regarding giving the state some degree of authority with regard to the governing in the area of immigration law.
And I mean, speaking of, finding a mediating position or finding a compromise, obviously, we've heard a lot from the governor and a lot of people who've seen the situation at the border that, there is a problem, that something needs to be done. But people raise concerns about this law, things like racial profiling, things like denying people their due process. Do you think this sort of forces lawmakers' hands either at the state or federal level to actually craft some legislation here that both sides can get on board with?
It seems as though we are at a constant impasse with regard to immigration law in our nation. This law passed by the state of Texas has its roots and its origin in the obvious failure of the federal government to enforce immigration law. And the states are looking for some kind of relief, some kind of alternative, and some kind of resource with which to battle the real immigration issues that they are up against. It will have to play itself out, and we will see if there's some kind of middle ground.
So, I mean, with this law in Texas, does this potentially set a precedent for what other states might do with regard to the issue at the border?
This particular law, SB 4 out of Texas, definitely will set a precedent and give guidance and direction to other states with regard to the extent to which they can also establish their own immigration policy.
All right, Dr. Eddy Carder, constitutional law professor with Prairie View A&M. Dr. Carder, as always, thanks for being here and have a great holiday.
Thank you very much. It's always good to be here.